Welcome back, viewers. We're talking about work cover and the very important issue of costs. Tony.
John, look, the point I'm trying to make is this. The sad thing about the system is that costs were blown out of proportion. There was instances where a claim was worth 80 to 100,000 and costs were 60, 70,000.
Shocking.
That's never going to work. So the WorkSafe Authority, in their wisdom, have introduced this new model. Hopefully it means there'll be early settlements a lot faster.
Well, that'll depend on the attitude of work cover, won't it, Tony?
Or both parties. It will depend a lot on the lawyers as well.
Yes.
If you've got the lawyers that are cooperative and they make a proper assessment of their client's claim, then things can resolve a lot quicker.
Yes.
Do you
That's
agree
correct.
with that?
Absolutely.
So look, this is not a bashing of WorkSafe here. This is about explaining the system to people.
Yes.
Isn't that right?
That's right. Look,
Yeah.
WorkSafe were concerned about escalating legal costs, and they're worried about the integrity
Look, we're all
of the
concerned
scheme.
about it. We don't want the system to fall over because that means future people that get injured won't be covered. You know, we lost the system once.
We don't want the policies of Jeff Kennett to come back, Tony.
No, we don't want that, do we, Carol?
Absolutely, because it does cost employers to have an expensive scheme. So, yeah, in that
And
respect,
I
it's
don't want to be
important.
explaining to workers, sorry, you don't have a common law damages claim, but because Mr. Kennett got rid of your common law rights.
Yeah.
I don't want to be saying that.
We want to make sure that people retain some sort of level of compensation into the future, and so let's hope that the system works well. But John, getting back to this, what do you do when you prepare an application? What's the process?
Well, we prepare a serious injury application. It's a work cover serious injury application for either pain and suffering or economic loss. You need to draw an affidavit. You need to prepare an affidavit, Tony, have all relevant medical documentation, including clinical records, treaters from all, medical reports from all treaters, and maybe a medico-legal specialist. And you have to get the call right, Tony, from the start, whether or not you are to pursue a pain and suffering and economic loss claim or just a pain and suffering claim only. Now, that will depend on whether or not your client is working or whether or not they will meet the threshold of 40% or more economic loss.
Just on that point, Carolyn, a lot of clients do make it difficult for lawyers, but don't they? They're sort of working part-time,
That's right, when they come...
light duty, sheltered employment.
That's right.
We need to have an informed decision about their future capacity. Look, the idea is to try and get people back to work where you can.
Yes.
But you don't want the one that's sort of hanging on for dear life if you know they're going to conk out. Is that
Well, a lot
fair?
of people make really commendable efforts to get back to work, and they work despite being in pain. So when they come to see us, they're in that situation. The clear-cut cases are easy. The ones which traumatic injury, they can't work, they'll never work again. They're very
But
simple.
there's not many of those, surely.
There's a lot of borderline cases, and you have to really crystal ball gaze as to whether they'll meet
And
the
John,
test.
it's hard to work out in some instances.
Yes.
You can't pick whether the person's going to conk out, can you?
Well, you'll give it a try in the sense of in consultation with the treaters, with medical documentations, and with your own client. However, Tony, your client, the worker, must be aware that if you do not pursue economic loss at the time of lodging the serious injury application, there goes his economic claim forever.
He or she. So there's a double
Correct.
whammy here. If you get it wrong, you miss out on legal fees and you've got to pay out of your own pocket.
That's right.
Two, if you don't put it in, that is a loss of income, and then it turns out you can't work, you've lost your rights to pursue it.
You've lost your lump sum rights to pursue economic loss. However, of course, as you know, Tony, you're always entitled to weekly payments.
Yeah, it's not as attractive
But
because
it's
it means
not
you've got to
as
sit around the
attractive.
house and, you know, mope around, and we really don't want that. We want people to be productive out there.
Actually, I
So-
think I might just raise people need to know too that the pecuniary loss damages can be really, really significant. In fact, John, you ran a very successful case in the Supreme Court where the client got over $1 million, didn't you?
Yes.
And
yes,
800,000 was loss of income, wasn't it?
Matter of Dong Pham, an Asian male who was working in his early 20s as a labourer, sustained severe injury to his back. He will never work again. The jury in the Supreme Court came back with $800,000 for economic loss because he will never work again.
Yes.
But John, can I just say this, Carolyn? The real problem you've got is this. That's clear cut, that case that he won't work again. What
Yes.
about the ones that are borderline in the sense that we've still got to prove that 40% test, aren't we?
Absolutely, and like there was a time under the old regime before October last year where there was a sense of speculation. They had an arguable case, but it wasn't clear cut. So you'd be putting it under both heads of damages. Now, you have to make that election very early on, otherwise you could be severely penalised if you lose your pecuniary loss claim.
And we're talking about capacity, aren't we?
Yes.
The capacity of the worker to perform suitable employment.
As
Correct.
a prudent lawyer, what would you do these days? Does it mean you have to wait? Or what do you do?
Well,
what would you do, John?
Well, at times you may have to wait, Tony.
Or more information?
You need clarification as to the current medical circumstance of the worker.
But what
That's
about the
right.
ones that want to stick it out and see how they go for 3, 4 or 5 years?
Well, they do have the option of pursuing both heads of damages and losing, but they have to accept that if that's going to happen, there's going to be cost implications, and it will ultimately come out of their
So it's
settlement.
almost like a Russian roulette.
And the worker must be aware and must be advised that this is your one and only shot. So you can't rush into it, can you, Tony?
No, you can't. You can't.
So maybe you do have to step back and sit on the matter for maybe 6 months or a year to allow maybe the worker has to see an appropriate medical specialist, like a neurosurgeon.
Or maybe to see where they go through all the rehab to see how far they can
Or they
progress.
can maintain that job that they're only just managing now with. So,
Okay.
So there's a
Yeah.
lot of factors that come into play, Tony.
The vocational retraining, is there more of an onus on the insured or the employer to give this
No,
to the
there's-
worker?
The Act makes it clear the employer must provide alternative employment. However, at the same time, for serious injury applications, the Act then puts the onus on the worker that he must try to retrain himself.
Let me put this scenario to you, Kellen. You've lodged an application, it's for pain and suffering only, and then down the track, your client comes in and says, I can't work anymore. What's the answer?
well, if the application's been made in respect of that only, then that's pretty much the end of it.
Okay.
So-
But they've still got rights to...
Oh, sorry. They're able to claim weekly payments, which arguably can go up to age 65 if they've got no capacity for work at all. So they still get a damages payout for pain and suffering, and they can stay on weekly payments.
So it's a pretty tough call, isn't it, John? You've got
My view, Tony, is it's not something you can rush into, but at the same time, you need to get the call right from the beginning. And I'm more inclined than not to still pursue economic loss claims because of the upside to the worker, Tony.
There is a big upside, but at the same time, it's got to be a very informed decision. It's a client.
It's an informed decision. And it depends on each particular case, doesn't it, Tony?
course.
Whether or not the
Yes.
worker is actually working or has a capacity to work. Now, if we're talking about someone that's left school in year 8, blue-collar labouring work all his life, well, and he's suffered a severe back injury, well, the indicators are he has no work capacity. Particularly if we're talking about someone in the maybe 50s who can barely speak English, how is such a person going to be retrained?
That's a very good point.
Well, exactly. It's more difficult for younger workers or for people who are really skilled, can do alternative work. And it's also difficult for people who are on a very low income at the time that they were injured as well.
Look, viewers, what it means is make sure you ask a lot more questions of your lawyers, make sure that you listen to your lawyers, and at the end of the day, a more informed decision's made, and just keep asking questions and pursue your claims. You got rights. It's just that there's going to be a lot more cost to the individual. Okay, look, after the break, we're going to Kathy's mailbag. You're staying on with us, Caroline. So,
Absolutely.
John,
Love
thanks
to.
for coming on
Thank
board.
you, Tony.
Appreciate it.
Thank you, Caroline. Thank you, viewers.
So stay tuned,
Thank
viewers.
you.
Don't go away. Thank you.